Everybody's waiting for the next surprise. Skeleton Jack might catch you in the backpack.
Scream like a banshee, make you jump
Out of your skin, this is Halloween. Everybody scream.
Please make way for a very special guy.
Old Jack is king of the pumpkin patch. Everyone hail to the pumpkin king. Now this is Halloween. This is Halloween. 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 Halloween.
Things everywhere. Life's no fun without a good scare.
That's our job
But we're not mean.
in our town of Halloween.
In this town we call home. Everyone hail to the pumpkin song.
Hello, hello, everybody. It's Artie of Artie's Corporate Fiction. How are you guys doing? Happy Wednesday. Happy Hallows Eve Eve. We're gonna go back to form for sure. I know I've been out for a good while. Been streaming on the other channel, playing some spooky games, but also been dealing with a lot of work, and so it's been like pretty exhausting. So we're gonna go back into the courtroom antics. I know I've missed out a lot. I know people have mentioned this one a lot, Mr. U.S. Army Sovereign Citizen, and apparently he's gotten some assistance. Apparently he decided to not learn his lesson. I shouldn't be surprised, but here we are. As far as tomorrow goes, I haven't decided what I'm going to be playing tomorrow evening. Maybe Phasmophobia. What else is in my playlist? Spooky games. Could go back to Layers of Fear. So those are the two that I could play. So why don't you guys let me know what you're looking for. Anyway, we're gonna start off with this guy. I know a lot of the other OSG videos are out there that I haven't seen yet, so it'll be interesting to watch. We're gonna start right here.
I want you to stop talking, or you can go upstairs to the county jail.
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
Oh, okay, this is a recap.
Right, you can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers. The choice is yours. Either leave.
Your Honor, I'm trying to
or
understand.
leave disruptively.
I'm not being disruptive. I'm just trying to understand the nature and cause of the
All right,
charge.
officers, I'm gonna close
What
it.
am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief,
All I'm asking is to understand the charges. I don't know what jurisdiction is these charges being brought to me under.
Ms. Gillette, I'll see you at 30 docket.
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
No.
All right, well,
Can I go home?
I
We're too
left
late.
it up to them, and I left it up to you, and then they were to behave accordingly.
And you get a
No,
speeding
we're not
ticket.
gonna do that, sir. I just need.
All I want to know is the fine. Like normally when you get a ticket or something.
See, here, while he was in jail, he sounded, or at least it seemed like he was a bit more reasonable in this second video. It seemed like it. But obviously, that was doesn't sound like that was the case.
Citation, somebody give you.
I've told you that. I've told you that.
A
When
little
you
bit
held
more
me in
reasonable.
contempt, they went out and searched my car, which was a violation of my Fourth Amendment right. They never issued
Probably
me a search
inventoried.
warrant. They never told me my vehicle was suspected in a crime investigation or any kind of criminal intent or doing anything. So my car was searched.
Well, I think as I understand it, you were put on lockdown because you wouldn't go through booking and processing. They couldn't get you entered into their system.
No,
You
well,
refused to get your fingerprints and you refused to get your photograph, and rather than manhandle you and wrestle you and get you to take your pictures and prints, they had to just put you somewhere safe until you would cooperate. But
that
that's
wasn't
what
the
I've heard. I don't know that for a fact.
Well, if you look at the video, that is inaccurate. When I came in, I was told I was gonna be.
Okay, sir, we'll talk about that just a little bit. Okay, well, Missy, there's no one else hanging around like.
No.
Oh
Mr.
yeah. Oh, that's right. I completely forgot. He went AWOL on his third appearance. What am I saying? I completely forgot. He went freaking AWOL in his third appearance because of the medical emergency.
Johnson has called again this morning, and
Oh, yes.
he's
Yes.
supposed to be faxing something. My fax machine just went off, so let me see what it is.
Is this the individual who's
This
a sovereign citizen type?
Sovereign
thing?
citizen military. Yes, and he is really military.
Sovereign citizen in the United States military?
Yeah, I know, right?
I have something he sent us. Mr. Johnson he's filed several pro se motions. I'm not quite sure what they're saying or what his goal is. I had told him to be here in person because of his prior history and contemptuous behavior.
I asked that we set this over to October 25th.
All right, I'm looking for a Johnson. Do I have a Johnson?
Oh boy.
Yes, you do. I am
Danny?
here. Can you hear
Wait,
me?
what?
Yes, but
who
you're
are
not the
you?
Johnson I was looking for, but I will take your case up. I have a couple. I have a Danny Johnson, and well, don't I have her on here? Oh, she's Stasha Carter. Do you go by Johnson also?
Okay, so I'm here for Danny Johnson.
Oh, are you the attorney?
I'm a representative for him.
Oh
What's
no.
his-
Oh no. Oh no.
And that means I'm his wife, and we sent
Okay, are you an
documentation.
attorney?
I'm an attorney, in fact.
Ah!
You're not an attorney
No!
at law?
All right, let's go. Let's go.
No.
Okay. So when
So-
you say
so
you're an
Mr.
attorney, in
Johnson-
fact, you're not an attorney, but you're here on his behalf as a citizen. Is that
No, I'm
right?
not a citizen. I'm not a citizen.
Hi,
But
S.
let me state for the record, Mr. Johnson is under doctor's care. He's in
Oh, boy.
recovery. We sent the documentation over to the court.
Just for if there anybody has questions, no, your spouse cannot represent you unless they're a licensed attorney. And no, yeah, I swear to God, Jess, if she says she has power of attorney, you know what? I'm giving everybody bingo.
Courts to show that, to show proof of that. We also reserve our rights to any and all reproduction of or distributing of videos on social media platform.
Ha.
And
Uh-oh.
we request the matter to be rescheduled at a
Are lawyers allowed to represent family members? They can. It's just discouraged.
later time when he can get through his recovery period.
All right, Mr. Johnson failed to appear at his first appearance, February 27, 2024. August 13th, 2024, he appeared. We took formal first
Oh,
appearance.
wait,
He entered a
sorry.
not guilty plea.
The game.
Actually, he objected, I think, to
There you go.
just about everything that we did. He was argumentative, disrespectful, interfered with court proceedings. I believe
I object, Your Honor. I think he was
Stop.
he was-
You don't have any standing here today, Miss Carter, because you're not his lawyer. You're not him.
I'm not Miss
Mhm.
Carter. I'm not Miss Carter.
Then why does your screen stay Sasha Carter?
That's what it says, but I'm not Miss Carter. And it says
Who are
Stasha.
you? Who are you? Before I
Then
disconnect
who
you
are
from these
you?
proceedings, because you don't have
Or
standing
I'm
to
gonna
be here.
eject
What's
you.
your name?
Well, again, Mr. Johnson is under Dr.
Do you want to
Mr.
tell me
Johnson is
your
here.
name?
He's here. I've already gave you my name, ma'am. I'm his
Well, then
wife.
say it
I'm
again,
Miss
because I
Johnson.
must have missed it. What's your
Miss
name?
Johnson. Miss Johnson.
What's your first name?
Nicole.
How do you spell that, please?
Uh-oh.
Nicole.
Nicole Johnson, and you said you're his wife. Is that
That's
correct?
correct. That's
You're
correct.
his legal wife. Okay. Now, if you'll let me continue, and if you won't, then we'll have to remove you from the proceedings. On August 13th, 2024, he became, as I said, argumentative, disrespectful, and interfered with the court proceedings. I found him in contempt. He was arrested and he was to serve 24 hours in jail. And then, as I recall, the military put a hold on him, and because of whatever reasons, he served more than 24 hours. But he was told to be back here September 27, and
Still cannot believe that he's active duty military and pulling the sovereign citizen crap. Somebody asked earlier whether or not this could affect it. Of course. I mean, if he pulls any of this inside the military, he's gonna get brought up on discipline, and the UCMJ. Outside, if he continues with his antics outside and keeps getting in trouble on the civil side, then I can also have repercussions with the military as well.
on September 27th, there was an issue that he either was or was not receiving medical service, and he wanted a continuance, and we ultimately continued it to today. Now, that's been a month ago. And you say he's still under doctor's care and can't be here today, or is that, what were you trying to explain there?
What I was expressing, ma'am, is that he was in surgery on the day of the court date. He had
30 days
actual
ago,
surgery.
he was in surgery. Okay.
Correct. The doctor put him under doctor's orders to stay on bed rest. And that's where he's currently residing at, on bed rest. And we sent in the documentation to the courts and the doctor.
True, Tones.
The doctor notified the courts that he's not to appear because he can't travel and he can't fly due to his surgery.
Okay.
And we've made it clear to him that he can appear by Zoom. So I'm going to issue a bench warrant, bond forfeiture.
Hold on one second, ma'am, because he is here. He can hear you, but
Well, then put him on here.
Then put him on.
Oh, he's on here, but he's in a recovery bed, ma'am, and it's a violation of his rights, his HIPAA rights, to be shown and be broadcasted all across social media as far as
bench warrant, bond forfeiture, no bond hold.
Based.
Miss Western.
Oh, hi. Oh, now you want to appear.
Now do you want to be on here, sir?
Well, I'm first of all,
are you voluntarily appearing, Mr. Johnson?
No, under duress.
Okay, I'm not duressing you at all. You don't have to be here.
Can I speak, please? I just want to let you know I'm on a series of medication that alter my
mental state.
I'm on a medication that I'm supposed to be on bed rest from my procedures for the next 8 weeks and for the following 8 weeks, and then I'm supposed to start my recovery. But I have reached out to the courts. I have had the hospital reach out to the courts in reference to my procedure and my process. I have requested a continuation. I have also sent in letters to request evidence from the case to continue the case prior to these procedures that I have not got a response back. So
certified mail.
I sent it out registered mail that the courts received, I think, on the 23rd.
Registered is not the same thing as certified.
In requesting evidence of the case to continue prior to my surgery, but having the surgeon
It's an unforeseen circumstance.
Ma'am, I want you out of the case now. You're not
Yep,
his
you need it.
lawyer. He's talking,
not
he's
his lawyer, too.
representing
Ma'am, the
himself.
creator,
You're
the
out.
creator made me his wife, and
I
we,
will find you in contempt of court.
Yeah, you can.
ma'am.
Stop talking, Miss
Shut
Johnson.
Up.
Okay,
Now, both of you stop for just a moment. Miss Gillette, you haven't had a chance to say anything on this. Do you wish to be heard?
Because you're acting like the attorney.
I'm acting like the court.
Oh no. Okay, she's serious. She needs to stop with the back talk, or else, yeah, she needs to hold her. Actually, you know what? That alone should have been enough to hold her in contempt. Her continuing to back talk to the judge, she should hold her in contempt right there.
And you owe me $50, ma'am, for contempt. And if you have
There you
another
go.
outburst,
Based.
it's going to go up and it will be enforced. $50 direct contempt by Nicole Johnson for her interruption of the proceedings. Ms. Gillette, do you wish to be heard?
Good luck with that.
Ooh, what? Oh! She just said good luck with that. Oh no. Oh no. I would have said, okay, that'll earn you 500. I would have said that's okay. We're gonna 10x. We're gonna 10x this just for that little little statement right there.
Ms. Gillette?
Sorry, I was making notes, Your Honor. In this matter, there have been lots of issues with Mr. Johnson. There is a letter here. I don't know if it came directly to my office or through the court. It's through the court because it was filed in the court file of
All right, so when you
his.
say through the court, you mean it went to the clerk?
It went to the clerk
Okay.
and was file stamped. There
And it
is
may or may
a,
not have made its way to my office, but if it has, I haven't seen it for the
Right.
record. Go ahead, please.
there is a note from seen September 25th, 24. His other hearing would have been the 27th. Asking he be excused. We've had lots of issues with Mr. Johnson in the past. I am taking into consideration that he has provided a doctor's note and information about
Okay.
that
But that was
visit.
the last hearing. What do you have, if anything, for today from the doctor?
That was received. It was file stamped 9/27. I don't know if he's recovering or not. I can't tell you anything about that. So if he is on medication, Judge, I don't want to have anything substantive unless he's not taking pain meds. So I would move it over to November for him to be here, present, and he needs to understand that attorneys can speak for individuals, but not family members unless there's
Mhm.
some
You
sort of.
you won't be released in November, ma'am.
ma'am. Miss-
Oh my God, she just said it again.
$1,000 fine or for contempt against Ms. Johnson?
Miss-
Okay,
yeah,
now,
the
Mr.
court.
Carter, you may speak. Yes, sir.
Meanwhile, Jim over here, he's enjoying this. Jim's like, hey, honey, listen to this lady's like chalking up contempt charges because he won't shut up.
Now, if you're
Ma'am, do you even know who you're talking to, ma'am? Could you call
What the fuck? What? My God. All right, I think at that point I'd probably throw her in jail.
calling all these names? Which name? Who are you speaking to?
You told me your name was Nicole Johnson. I'm speaking.
Correct. So
to you.
you calling Carter, and I expressed to you that nobody's here is Carter.
Well, don't have to put Carter on your screen if you're not
Well,
Carter.
ma'am, we made the point to be here in court today, ma'am.
You
And that's under the
stop talking.
unforeseen circumstance. He's still
All
here.
right, I'm going to end this talk. This court is
over.
over. Bench warrant, if you don't stop and get out of it. If you don't want this
Okay.
bench warrant, you be out of this conversation and
Ma'am.
let me communicate with
Jim is like, I'm recording this
But
shit.
the defendant.
Ma'am, there's
Obviously,
no
Mr. Carter
defendant.
doesn't have any
He hasn't been
control over
convicted
you.
of anything.
Okay,
Oh,
Mr. Carter,
or not, he's out.
I'm gonna have to end this court because the woman won't shut up. I'm
Oh,
gonna have to leave a bench warrant. If you can get her to shut up and stay out of the conversation,
I
you and I, sir, can have a hearing. Now, okay. How much time do you need this continued, Mr. Carter?
okay.
The doctor can send over the information.
oh my God.
Mr.
Okay,
Johnson,
Oh no, oh wow. Oh, the judge is now really pissed.
I'm sorry, Missy, can you get that
Hey,
Carter off of
hey,
there?
hey, I'm trying to explain to you. The doctor told me it's going to be 3 to 6 months for my recovery.
3 to 6
So
months for your
I
recovery.
had it's a middle back procedure. Like I said, I haven't even started physical therapy yet.
Do
So
you have an attorney, or would you be willing to take a court-appointed
I,
attorney?
as far as the attorney, all I would coming to do is, because I'm on medication, I don't want the court to hold anything against me that I may say due to the type of medication I'm on. And
I
two is the
understand.
fact that I am requesting a continuation. I know y'all saying I was being whatever, but at the end of the day, I'm requesting a
being whatever.
continuation at least to December, late December or January.
All right, we're gonna set this over for trial. It'll be for bench trial. And what the doctor told you you'd be in recovery for how long?
I be 3 to 6 months for
Okay, so this
recovery.
is October, November, December, January. I will continue this. Missy, what do we have mid to late January?
January.
They're ethical.
She keeps
Is that
muttering,
that
and
month
I'm
that
like,
is really challenging.
Yeah, but we do have January 31st at 11 available.
All right, January 31st will be your bench trial. Now, did I understand that someone did receive something from his doctor today or recently? Ms. Gillette, you were talking about something from a month ago.
What time?
Yes, it was filed September 27th. It said he had surgery.
Yeah,
And it was an
we
excuse for the
continued
27th.
that hearing based on that letter. We continued it to today. But has anybody seen anything more recently?
No,
I think the wife was reading something that said he couldn't travel, but I don't think it said anything about appearing by Zoom. I think it just said he couldn't travel or appear in that fashion. But that's what we need to make sure come January, that the doctor understands this can all be done by Zoom. And again, Mr. Johnson, would you consider appointment of an attorney to represent you?
Not at this moment, Your Honor. Like I said, I'm on medication.
Well, an attorney could sure help you navigate through this court system. I
true.
understand you wanted to represent yourself, but the attorney could sure help you.
I don't need an attorney at this moment.
All right, we'll document that for the record, Ms. Gillette, in the journal entry, that he still does not want an attorney. That we are continuing this again at the defendant's request for medical reasons to January 31st, 11 a.m. Now that's going to be for bench trial, so keep that
Better
in mind.
prepared,
The state
buddy.
will have their witnesses ready, and if you have any witnesses, you'll need to have them ready. Hopefully, you won't be under medications January 31st or in any situation that's going to affect that. But I won't issue the bench warrant. Nicole Johnson does owe me $100, or she owes the court $100. I'm going to give her 10 days to pay that. If she doesn't pay it, then she's going to face more contempt. That payment needs to be paid, Ms. Johnson, to the clerk of the district court. And that is in Eureka, Kansas at 311 North Main. And make sure you put on there contempt for case number GW 2024 TR 22. That's, and put on there that it's for payment for direct contempt of Nicole Johnson for continued, well, you won't have to put on there other than for contempt. But I do want the rest of it put in the journal entry, Miss Gillette.
Well, if the presumption is that he's not going to be under the influence, like, at the time of trial.
Ma'am, you don't have any rights in this hearing today.
I do. I'm not a citizen, ma'am.
What?
Ma'am, you don't have any rights in this hearing today.
I do. I'm not a citizen, ma'am.
I don't care what you consider yourself. You do not have any right to come into any court of law and start interrupting and delaying the procedures and absolutely deliberately and intentionally disobeying what the court instructs you.
Ma'am, I called the county attorney yesterday. I called the clerk yesterday.
I am going to tell you to stop talking one more time before
I know, because you want me to, you don't want me to express my rights.
This is
Oh my
not your
God.
hearing. This is not about you. I really
Well,
hate
you're
to have
making it
to
about
send
me,
the
ma'am.
sheriff to
You're
whatever
making it about
state
me.
you're
You have
in.
not given no lawful consideration to this matter,
Mr.
ma'am.
Johnson.
He's under doctor's care. He has provided all the documentation to show that he's under the doctor's care, ma'am, and you have not given no consideration to that.
You are so fortunate that you're not here in person, or you'd be locked up right now.
Yeah, I
True.
am.
Mr. Johnson will be locked up if he is not here in person. Mr. Johnson is ordered to appear in person for bench trial, January 31st, 11 a.m. Ms. Carter.
Yeah, because you want to retaliate against him, don't you?
Ms. Carter now owes $200 in fines, and I'm disconnecting this call so I don't have to send the Greenwood County Sheriff to whatever state she's in to get her picked up and locked up for contempt. This hearing is adjourned.
Ma'am, every time somebody
Oh my God, she's mocking the judge.
expresses their lawful rights to defend themselves, you hold them in contempt. Why is that? You are a judge. You are compelled to provide protection for we the people. You are acting as an attorney, giving advice to people, talking, bringing people down, and he's in a situation to where he's under doctor's orders. It's a shame that you still wanted him to present himself under the doctor's orders of bed rest and medication before the court.
Put the camera on yourself when you talk to me, Ms. Carter,
and you
or
can
Ms.
put it out
Johnson.
across social media, and you can talk down on them, and you can make money off of it because you go and you spread it, and then you get up all these views.
Put the camera on yourself if you want.
Oh my God. Now she's like the judge. Oh no, she thinks she operates the OSG channel.
Off, Miss Johnson.
I can put the camera where I want to. That's my legal
All
right.
right.
Whoa.
You are to appear. I will send the orders for you to appear personally because you're going to serve some time for this.
Oh.
Respect. Miss Johnson.
It's disrespect with what you having him do
Missy,
on camera.
disconnect her. This court hearing is adjourned.
Yeah, disconnect yourself because you're unlawful.
Oh my God. Holy shit. Oh my God. Oh my God. All right, that hearing is gonna be cinema. Oh, that hearing is gonna be absolute cinema. I cannot wait for that hearing. Please tell me that that's going to be live streamed. Oh, please, it has to. It has to be. Damn. Okay. Pre-trial conspiracy motions. Oh boy. Or another Detroit sovereign citizen. All right, let's try it.
Your Honor, David Recap, City of Taylor.
All right. And for the defense?
Good morning, Your Honor. Attorney Josh Hadley. I appointed counsel on behalf of the defendant, Mr. Eric Martin. Briefly, Your Honor, I'd like to make a record. We were before this court last week and there was a motion a pro se motion filed by Mr. Martin to have me replaced as counsel. I was never served a copy of that. Your court graciously did send a copy. I have had a chance to review it. Your Honor, I would just again state that if Mr. Martin and I have a fundamental disagreement as to trial strategy, pursuant to People v. Charles Williams 386 Mish 565 1972, good cause exists for a substitution of counsel.
Yes, but I now putting it at 1.25 speed.
If there's a difference of opinion between the defendant and the appointed counsel with regard to fundamental trial tactic, as well as going to People v. Bass 88 Mish 793 1979, good cause can also be found when there's obstruction of communication breakdown. Now, my recollection, Your Honor, your basis last time I denying the motion was really how late in the game the motion was. It was going to be prejudicial, essentially, and disruptive of the judicial process.
That's correct.
If I recall correctly, one of the other concerns we addressed was the concept of Mr. Martin's belief, which I think we've now clarified, that I'm not restricting him from speaking in any way, shape, or form today.
No.
Very well. Your Honor, I would also like, I believe, again, I don't want to put words into this court's mouth. My understanding is my role today, as if Mr. Martin wants to advance the defense that he has selected, I'm here to aid him with the understanding of the Michigan court rules, the Michigan rules of evidence, and all federal and state applicable law.
That's correct.
Very good, Your Honor. Okay, because of that, again, I think I just, for Mr. Martin and myself and this court and the people to be on the same page, for these reasons, I will not be making an opening statement, or I will reserve an opportunity for a closing argument.
And I will say this, I'm going to go ahead and give the ground rules to Mr. Martin so that he understands. Mr. Martin, you are lead counsel. You are your own lead counsel, and you choose to be representing yourself. Is that correct?
Oh boy.
To present myself, not to represent. I am myself.
Yeah.
I'm going to tell you this right now. I'm going to say it one time. I'm not going to sit here and split hairs on meanings of words. To represent oneself or present oneself.
Thank you.
It's the same thing. You are speaking on your own behalf. Yes?
Right, yeah.
Right, very good. Both of them mean the same thing. So we're not going to play semantics because literally I'm a walking thesaurus. So I'm not going to do that. And I'm going to shut that down because you're just going to waste time. I'm not here to stall and waste time. I'm here to make sure your due process and you have a fair trial. And as part of that fair trial,
oh, really? He teaches con law? Oh boy.
you're not going to try to disrupt the proceedings by either stalling, playing semantics with, oh, it's present instead of represent. It literally has present in it. Represent just means to redo it again. That's all. And so every time you go up, you're just representing yourself again. You're representing is what it means. That's what represent.
Trying to make the semantics it does.
So anyway, so here's the thing. You're going to be the lead counsel, so you're going to do your opening statement and things like that. You're going to follow the court rules. You're going to follow the same rules of evidence that everybody else follows. Mr. Greco is not going to have any advantage over you. You're not going to have any advantage over him. If you have, you literally have a legal encyclopedia sitting next to you. Someone who is very confident in the laws and the court rules and the statutes and the rules of evidence. So if there's an objection or things like that, I will pause. I will pause. So that if you think that there's an objection and you think that there is something like that, I'm also going to ask you, because you have someone who is so astute at trial practice, if your co-counsel, are you giving your co-counsel permission to say objection when he sees something objectionable that you don't recognize? Because I'm just saying you don't have a Juris Doctorate, you haven't formally studied the rules of evidence in a formalized setting. You could have done so online or anywhere else by library or by book or whatever. I don't know that you have or haven't, but I don't want to presume. But I just want to know for the flow of things, because if someone says something,
really? Wow.
They're going to keep asking questions unless somebody jumps in with an objection. If you don't recognize the objection, but he does, are you giving him permission to assist you by saying, hey, hold up, that was objectionable?
Yeah, as long as he's going by the law and not doing nothing that's going to violate my rights.
Well, I just want to know. I mean, and I'm making sure that this is your protection. He's there for your protection. I'm asking this question because just from a flow of trial standpoint, somebody.
Yeah, sovereign citizens are absolutely incapable of giving a yes or no answer. They always have to ramble.
Who knows what's going on would be, because I do it all the time, sometimes sitting here. Like someone will ask a question and I kind of like, I'm watching. And I would have said objection if I was the other side, and they don't object. And I don't even know if they didn't pay attention or they didn't know, or I don't know. But I can't do that for you. I have somebody here who is very astute at that. Are you giving him the power? I know you want to speak for yourself, but this is the one situation where you have to respond like right now. You have to like block it, to like do something. And if you don't recognize it, I want to make sure that you are giving him permission for him to do that. Is that okay?
I want to do, but also reserve my right to also make.
No, sure. I mean, and I'll give you. All I'm saying is, I'm going to have him call the timeout. I'm going to have him throw the timeout flag by saying objection. And you two of you can talk about why it's an objection, and then speak to the court. Because if obviously you didn't see it or recognize it, he did. So there's probably a reason why. Because he's not just going to throw out the word objection for every little thing. You're also not going to throw out the word objection for every little thing. Because if you say, I'll give you three. If you came up with 3 frivolous objections in a row because you don't know the court rules, then I'm going to turn the case over to him because he knows how to do it. You understand what I'm saying? I got no problem with you and your closing argument, your opening argument, sure. If you want to cross-examine a witness, sure. But it better be within the rules, it better be as to the elements, it better be as to the case, not anything, some other tangent about anything else. It has to pertain to relevance. Because every single piece of evidence, I'm just going to give you a quick update on the rules of evidence. The first rule, rule 401, is that all evidence must be relevant. So if it has nothing to do with the elements of driving on a revoked license, I don't want to hear it. If it's anything to do with bias, yes, you can go into bias because that is one of the things you can do that up under Rule 403. But under Rule 403, there's also overly repetitive evidence. So if you're going to ask the same question 20 times, just in 20 different ways, you're going to get an objection, and I'm going to sustain that objection. You understand what I'm saying? Okay, very good. That's all. And I just want to make sure so that because everybody who's here, who's going to be in the jury, they have a right to serve as jurors. And I'm not going to have them. Are you representing yourself as lead counsel or knowingly and voluntarily?
I reserve my right to say what I want to say and help myself with the case, but it's also okay for him to, also want him to do his duty and offer me the effective.
So that's what I'm saying. I don't want to leave him in a position where he doesn't know exactly what his duty is. He's either lead counsel or he's just a helper who's just going to sit there. Unless you ask him a question, he's not going to do anything. That's why I'm trying to ascertain exactly what it is you want from him.
I see Ed.
Officer Rose, good morning, sir. I'm well. I'm always well.
Okay, well, first, remember, Slade, you said yourself, you said it was okay, Judge Slade, you said it was okay that I say what I want to say, and you say the basic. So I don't see what the questions.
But the questions aren't so much for you. The questions are basically because I want to define the parameters of what your co-counsel is going to be required to do. Because I'm not going to have a situation where you're like, well, he didn't say objection on this one time, and he could have had an objection, and now I'm going to sue him. Because you're basically asking me to appoint him, sort of, with one hand tied behind his back. He's either going to be able to do his job to the fullest extent and represent you as a zealous advocate that he is, or he's going to be an encyclopedia of legal knowledge sitting there only waiting for you to take the book off the shelf. I did create that one situation where you could let him carte blanche if he thinks there's an objection, say objection, which will just basically be a timeout. Then you can group or powwow, whatever you want to call it, about what that objection would be, and then we'll.
You're not allowed to say powwow anymore. That's offensive.
Moves and washes away all privilege too. Okay, so I'm just letting you know that, so you understand. So any conversations you have with counsel, even though he's not technically counsel, but he's your assistant counsel, any conversations you have are privileged. So unless you say, well, he just told me this, well, now you just went through it. So I'm just trying to lay these ground rules so that we don't run into this during the trial anytime. So that you understand and agree. And I just want to make sure that you are knowingly and voluntarily choosing to represent yourself, knowing that I would have given you full access to an attorney. You're choosing not to take that access and you want to represent yourself. That's correct?
I'm choosing to present myself, but also I'm not waiving my right to be helped by him because I still have the right to be. So obviously.
Okay. So if he sees any objections, he can do objections, but other than that, you'll just stop and ask him.
And like I said, then we can't. I ain't protecting the people. So I don't know what's going to happen. You don't. As long as he don't say something violates my rights, if he does, and I'm gonna let that be known. I'm object to him. Whatever.
Well, see now we're right back to. Right, so
there we go.
I'll just play it by ear. And if I think that you're doing anything at all that's contemptuous, or just trying to stall on this, then
or trying to piss me off
at that point.
But I feel very comfortable with the understanding of the speaking objections, just so I'm on the same page. Everything else I will serve in a co-counsel role until directed otherwise.
Yep.
Very good, sir. Thank you.
Very good. All right. So now, as to the motion. All right. So I see you filed a motion this morning. This motion is a motion and demand to dismiss or discharge this case based on equal protection clause violations. And I have read through your motion. And did you give your co-counsel the opportunity to read the motion? Just in case if he asks you any questions or if you ask him any questions.
Your Honor, I have had an opportunity to review all of the pro se motions that have been filed in this matter. So yes,
including the one this morning.
We had a chance to review it together.
Okay,
yes, sir.
You just want to make sure in case you need to assist and everything.
I guess I'll just add, I have nothing to add.
Sure. All right, so this is your motion, Mr. Martin. And basically it states that you think that there's a conspiracy between the police department, Officer Borg, Mr. Greco, and myself to prosecute you and keep you from getting your moped back. So
naturally,
not just it's not totally current. So okay, so the prosecutor calls herself supposedly prosecuting me here on this case when I have sought to prosecute Anthony Borg for stealing my moped, which is larceny, without my consent, in violation.
Yeah. So he tried to file a criminal complaint against the officer for stealing his moped when his moped was confiscated due to some traffic incident. Gotcha.
Declaration of Independence of 1776, along with my due process rights of the Michigan Federal Constitution. Okay, he had it towed immediately. And like I said, I filed actually state criminal charges myself with this court. They haven't been acting on. Greco here has not made no effort to prosecute it. And basically, like I said, so that violates my equal protection right. You know, if I'm being prosecuted, I have the right to prosecute when crimes being committed against me. But that hasn't been respected, in violation of my crime victims' right of the Michigan Constitution, you know, in addition to the due process. So yeah, like I said, so it violates equal protection clause violation, not allowing me to prosecute also for the crimes committed against me. Therefore, the case should be dismissed based on that.
Ah, of course.
And Mr. Greco?
Yes, very briefly, Your Honor, I just had an opportunity to look at it, and this motion has no basis in fact, law, or logic. Mr. Martin is being prosecuted validly because he was operating a moped on the road with a revoked license and or no valid license. The moped was taken or by area towing at the time because it cannot be on the side of the road and not left in his custody when he is refusing to acknowledge that he is supposed to have a license to operate a moped on the road. There is no basis to charge anyone else criminally or conspiratorially in this matter. So it should be denied.
That's all you need.
I'm sure.
Okay, well, first of all, state statutes cannot violate the Constitution. As we know, the Constitution clearly says that property is not to be deprived before a due process of law, before a hearing. That was, as you just admitted, it was taken by your told immediately. You know, without before a hearing, without any due process of law. It did violate due process. And besides that, based on my right to travel, my right to own my private property, I was supposed to take it anyways. So the state, even there's a state statute that seems to allow it, it's an unconstitutional state statute, and that doesn't override the Constitution. Again, the Constitution says private property is not to be deprived.
All right. So based on all the testimony that I just heard and reasoning, plus after having read through the motion, I am going to deny your motion. There is no violation of equal protection under Michigan Law 257.252A, which is the abandoned vehicle statute. Anytime that there's a situation where a vehicle has to be abandoned, obviously the driver of the vehicle was arrested for not having a driver's license. That vehicle can't just sit on the side of the road, because why? Well, that's the city's job to protect that, and it also becomes evidence of of what was taking place. Also, so it has to be impounded pursuant to the abandoned vehicle statute. Additionally, the due process that you say you are not going to seek, you actually will seek, because it's built into Michigan Law 257.904B, which states that when a person is convicted of an offense that's punishable by that section, the local ordinance, basically for operating a motor vehicle while their license is either suspended, revoked, or denied, the court shall order that the motor vehicle, if it is owned in whole or in part by that person, and the court shall order that the vehicle be impounded for not less than a period that the court orders, but not more than 120 days from the date of judgment. But what happens in the meantime and in between time is an actual trial that we're about to have right now. So that is the due process that the Constitution affords, because if it's
we are literally doing the due process right now.
Not guilty, then your moped gets put back to you. There is no cost assessed to you. The city will pay any cost for impoundment and fees. Why? Because you're found not guilty. So the fact that you're stating that you're not getting due process, well, we're about to start the due process, which is the trial. So for those reasons, your motion is denied. Now, you can put that in the file.
This is Michigan.
With regard to one other supplemental thing. So the civil infractions that are in here, the no proof of insurance and the defective tires, those both stem from the same incident occurrence?
That's correct, Your Honor.
And are we setting these for a formal hearing? Are we having these as a formal hearing now with regard to these as well?
However the court wants to proceed. I mean, if we have a jury, we've got a jury. I mean,
because the jury doesn't do these.
Right. I mean,
so
if you want to do
because what I'm saying is I have no problem if you're going to put in evidence and it's going to be the same witness and I got everybody here. I will make a ruling on these after and outside of the jury's decision-making and vision. So they're not going to see that. So they won't be influenced in any way by it as to, well, the judge said he's already responsible for those. He's probably guilty. They won't hear anything from that. I'm just saying I'll make that a separate ruling on this, but we're going to have the formal hearing with regard to these, because I think having a trial on this is about as formal as you can get. So, but all the decisions and everything about these will be outside of the jury's presence, because I don't want to taint the jury to think that, you know, oh, well, the judge said he's guilty of the other things, so he's probably guilty of this. They're not going to hear any of that. Just put it in your evidence and I'll make sure of it afterwards.
Okay, fine. So we'll just address it during the
it'll be part of the And Mr. Martin, with regard to that, you'll be able to cross-examine about anything like, the tires. They won't understand what it has anything to do about anything, because I'm not going to instruct them that they're even thinking about that. I'm the one who will make the decision on that, because these aren't jury trial things. It's just civil fractions. So, and that way they're not going to get into it or about anything or hear anything about it really, other than they're going to hear the evidence for everything. I need to hear the evidence about this. So if you have any cross-examination with regard to defective tires, if you have any cross-examination with proof of insurance, I don't know, maybe it was on your phone, maybe it was in your pocket. I don't know. I don't want to put it. I'm just saying you can ask about all those things and make sure you're doing that, because we are having the formal hearing on these as well. So they won't understand that it has anything to do with their stuff. I'll make that determination after they're gone. So that way it doesn't change their viewpoint of view. Okay. So
We're clear, Your Honor.
okay, very good. So let's go ahead and
Before we
any other supplemental matters.
I think there was one outstanding motion that at our last free trial hearing, Mr. Martin attempted to address with the court. I believe it was filed. I see a motion with an October 25th date. Is this the same argument?
October 25th.
Your Honor, it's a motion titled, motion for demand to dismiss, discharge these cases based on the attached legal arguments titled nobility. I don't know.
Title of nobility. Oh
People
no.
were served a copy of this pro se motion. I did get a copy from your court staff.
Okay.
Let me converse real briefly with my client to make sure he wants to move forward with this argument. Okay. My apologies, Your Honor. He is ready to move forward with this argument.
All right, so the only other outstanding motion, and then the last time we were here, I said on the day of the trial that we'll clear up any outstanding motions that had not been heard. The only last motion, and obviously you filed a new one this morning that you brought with you, and we heard that, we discussed that. So you have this other motion for demand to dismiss and discharge these cases based on the attached legal arguments of title of nobility. So give me 1 second too, because I don't know if it's. Did you have attachments to that? 'Cause I see that your handwritten. What I was saying, I have your loose leaf handwritten motion like I see on your normal motions, but then I see like some pages that are, I don't know, it says page 49 of 88. So there's not 88 pages to your motion.
That wasn't a mission across the page. I would have been a little more professional, I guess, but that's.
No,
I'll tell you how many pages that should be here.
I'm not speaking to your professionalism. I just want to make sure that I'm not missing the other 88 pages. That's all.
Yeah, that's on page now. 6, 7.
What do you want?
8, I'm counting 8 here. 8 in addition to the motion of the actual legal argument, you know what I mean?
Okay, so I got 4 pages of, I got 4 photocopy pages and then 2 handwritten. So 6.
You have 6 total pages.
6 total pages.
Hold on, I think you should have 8. Let me see.
One of the pages that's in our possession is a blank page that's looks to be a photocopy of a hand, just loosely notebook.
Let the record reflect. I'll just go through what the court has. And you tell me if I'm missing something, okay? So I have dated October 25th. It seems to be your title page where it says regarding City of Taylor versus Eric Martin. And it says sincerely Eric Martin in red. This is your opening first page.
All right.
And then I have the motion heading page based on the attached law that is in demand. It is demanded that to take judicial notice of. Okay, and so that's the 2 front pages. Then I have
8 pages of a legal argument. I just 8 pages on share.
So there's 2 handwritten, and then there's 1, 2. So I have page 49 of 88, page 51 of 88.
Oh my God.
It should cross out maybe maybe
Page
more.
53 of 88.
Yes, Your Honor.
I don't have 50.
pages. I have pages. That's what I'm trying to get us included.
Unbelievable.
Take it in the light most favorable to the improper defendant. So, all right. So, Mr. Greco, do you have a copy of this motion?
I do.
Okay, you do. All right. So, Mr. Martin, go ahead with your motion.
Yeah. So with this motion, basically what's already said in here is the driver's license. Okay, the U.S. Constitution started with Article 1, Section 10.
Oh boy, here we go.
States prohibited from granting titles of nobility.
Draco, thank you for the 12 months. I appreciate it.
Driver's license is a title of nobility. It's a special privileges.
What?
For so-called drivers. It's prohibited.
I'm sorry. Yes. All right, more pets. You're getting pets. What was I gonna say? Okay, so this is the first time I've ever heard somebody make the argument that the moniker of driver is a title of nobility.
Okay. So do drivers get the nomenclature of king, duke, duchess, governor? But what specific nobility titles are given to people who are drivers?
As it says, like I put in here, it's a privilege granted to a certain right here, a title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself.
And already the judge is like, "Are you serious?"
Phrases, volume 8A, page 40. A driver's license is a privilege which is granted by the state.
Sir, I'm going to ask that you not mumble. You have to speak up because it's hard to hear. I can barely hear you, and I know that Ms. Hancock is going to have a hard time trying to make a record of this.
Yep, this the title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, volume 8A, page 40. A driver's license is a privilege which is granted by the state.
Yeah.
There's a lot of arguments stated, but basically sum up, like I said, the driver's license title of nobility is special privileges granted to so-called drivers, or a select group of people, and U.S. Constitution, Article 1, Section 10 prohibits the state from granting titles of nobility.
Oh my God.
Mr. Greco?
Yes, very briefly, Your Honor.
That's his train of logic. So because nobles have privileges and driving is supposedly a privilege, ergo a driver is the same thing as status as a noble and therefore unconstitutional.
The argument that he's asserting with regard to this applicability to driver's licenses has no applicability whatsoever. As the court is aware, being a constitutional historian and an American, that the titles of nobility was a big deal at the time of the founding of our country with respect to nobility titles such as that you described as king, duke, things that would be granted to somebody just by either right or granted certain rights by that title that have no application whatsoever to a state issuing a driver's license for those that are.
We are so far removed from oh my God.
Obtain one in the state. There's no applicability whatsoever.
So I will note that the Oxford Dictionary defines nobility as the quality of being noble in character. That's one. Two, the quality of belonging to the aristocracy.
I mean, is he pulling this out of Black's Law? Which edition, Judge?
Aristocracy. So, like Mr. Greco said, that's like you're a monarchy or whatever your setup is, like in England, that kind of thing, Duke, Duchess, all that good stuff. So, contrary to Roger Miller and the fact that there is anybody who's the king of the road, it's not true. There is no nobility that comes along with a driver's license. When they use privilege to talk about privilege, that is in opposed to a right. You can either have something that's a right, or you can have something that's a privilege. And a privilege is something that can be regulated for the safety, health, safety, and welfare of all citizens. Like I said, you keep talking about a right to travel, you got a right to travel. You know what? You can walk anywhere you want to. But if you're going to use something that can hurt somebody else, that needs to be regulated, such as a plane. You can't just go and buy your own helicopter. Just, you know what? I'm tired of all the traffic jams. I'm just going to fly my helicopter from my backyard, land it on top of the courthouse, and then I'm going to just, park here. You know what? You can't do that without a pilot's license. Why? Because you could literally kill people, like if you fall out of the sky. So there's a reason cars can kill people. It's no different than why you have to have a permit for certain weapons. We have a right to, and that's the clear right to keep and bear arms. But you still have to have certain weapons. You have to have a permit for those things. And so there's regulations that go along with that for the health, safety, and welfare. And getting a driver's license is because we want to make sure, the state wants to make sure that anybody who's driving has the basic knowledge and understanding of what it takes to drive safely, so that it's going to be for everybody, for everybody's benefit. So with regard to the violation, there's been no deprivation of your constitutional rights, and there's been no violation of the Constitution. And the fact that you need to have a driver's license is something that has been ruled upon by the Michigan Supreme Court, by the United States Supreme Court, and the right to travel does not supersede your ability to need a driver's license. You can travel all you want to, like I said once before. You can walk yourself all the way from Forest Gump from here to across the country and all the way back. But you got to do it by walking, maybe even riding a bike or something that doesn't require a license. But for licenses, certain things need licenses. There's a reason for it, and all of those have been hundreds of cases that say, yeah. So for those reasons, your motion is denied. So now let's begin by bringing in the jury.
To object to that, I'd like to respond to something that you.
There's nothing to respond to. I've made my motion on.
I
made my
denied the
ruling on your
motion.
And your motion is denied. If you want to appeal it, you can appeal it to the circuit court, but that's between, all right, so.
I will be
right
appealing
now,
actually.
we'll be getting to those.
All the verse, we won't provide notice that the court will be appealing all the issues that's
Duly noted.
verse and
Duly
deny
noted.
my motions and demands based on my constitution.
Duly noted. All right, so I have, Detective Hidden Host is going to sign in real quick because he has 3 different felonies to swear in.
Just take a step outside for a moment. Ron.
Sure. So I'm going to give, we're going to go on recess, probably 10 minutes.
Sounds great, Your Honor.
I don't remember you saying it. I don't remember saying it.
Anything,
No, Mike.
Detective Hidden Host is going to sign in real quick because he has 3 different felonies to swear in.
Just take a step outside for a moment. Ron.
Sure.
Please
I'm
don't
gonna
lay
give,
on the
we're
keyboard.
gonna go
Please
on
don't lay.
recess, probably 10 minutes.
Sounds great, Your Honor.
And he's laying on the keyboard.
I don't remember you saying it. I don't remember saying it. Well, I don't agree with that. So let him say it. Doesn't, and I won't do it.
Mr. Martin, hang on one second. I just want, let me mute the.
I'm sorry, let's
No,
take
I
this
did, I
conversation.
don't want, your table is mic'd up. And I am broadcasting live stream, so like. All right, and Mr. Martin, I want to, hang on one second. This counsel, is this on the record or off the record, just out, is it on the record outside of the presence of the jury, or is it just off the record question?
Your Honor, this would be outside, on the record outside.
So, what exactly, where is this hearing officer from?
Michigan.
Livonia, Michigan. So, I'm going to make a ruling in limine that this guy from Livonia, how does he have anything to do with
Oh no, is he bringing in like a guru?
the allegations that happened on the day of you driving your moped without a license?
Because, okay, now.
Was he driving? No, yes or no, yes or no, was he driving?
He denied me my driver's license. I tried to get.
Okay, then that's between you and the state,
I
there's
tried to
no,
get the driver's license.
that's between you and the state. And
Oh no, apparently this is like, no, this isn't a guru. I guess it's whoever works at the DMV who denied him his license reinstatement.
that has nothing to do with him, and he can't even be called as a witness in this case.
So until he violated my due process. I can't
That's
grant him
between
any-
you and him and the state and any sort of 42 USC.
Yeah, that's what it sounds like. It sounds like he's trying to call whoever was at the DMV who denied his reinstatement.
1983 case that you want to go file, you go ahead and take care of that in federal court. But that guy has no relevance of anything in this case. He wasn't at the scene. He wasn't making you drive. He wasn't there driving. He wasn't riding piggyback with you. There was nothing going on. So this hearing officer from Livonia who denied your driver's license has nothing to do, absolute zero relevance. I am the gatekeeper of evidence. Rule 401 specifically says that 402 says all evidence must be relevant. And if it's not even admissible. I'm going to tell you that right now. Whatever this hearing officer from whatever you did to try to get your license back, restoration in Livonia has nothing to do. He has absolutely zero relevance in this proceeding. So because of that, under the rules of evidence, I can't allow him to even testify because he has nothing to do with anything. So because he doesn't need to testify, there can't be any defense based on him because he has nothing to do with your case and the allegations of you breaking allegedly the law. So your motion to adjourn the matter, because you got to go get this guy as a witness, is denied.
Let me explain further. I'll explain how it is.
There's nothing to explain further. I've denied your motion. I'm not going to keep explaining. Once I make a ruling on the motion.
And of course, this guy is going to go to wherever Facebook forum or Telegram group, and he's going to claim that the judge railroaded him, for being abrupt and denying his motions. Not because they're full of BS, but because the judge is firm in saying motion denied. I'm not allowing you to ramble. Moving on.
And that's the end of that. That's the end of the discussion.
Counsel,
is there anything you'd like to add?
No, Your Honor, I advise Mr. Martin, again, once this court's made a ruling, be it on spoken objections or anything moving forward, if there's continued to be banter that he's been advised can be held in contempt of court. I appreciate the court giving us some leeway through this. Do we have any other preliminary matters? Your Honor,
Yes, I do. I still have other things to say as to my rights, yes. And I have another motion to dismiss based on my rights.
What is your other motion to dismiss?
I move to dismiss
Third motion to
because
dismiss.
of the Declaration of Independence of 1776, governments
Oh my
derived
God.
their just powers from the consent of the government. I never consented to be ticketed. Never consented to these court proceedings. I'm only here by threat and duress.
Ah, there it is. I did not consent to be ticketed.
Because if I don't, could be arrested and all that, that's the arrest. So it violates the Declaration of Independence of 1776 and also Article 4, Section 4 of the U.S. Constitution, my right to Republican form of government. This is all the flags right there, the gold fringe flag, that represents a military jurisdiction.
Oh my God, we have not heard the gold fringe flag in so long. That's an absolute bingo. That is an automatic bingo. I feel like it's been ages since we heard someone drop the gold fringe. Oh my goodness. Classic memes. Classic memes.
You can't hold it against me over my right to Republican form of government. It violates my right to Republican form of government by trying to enforce this military jurisdiction over me. These statutes, which what it is. And my right to Republican form of government means my right to common law. And I demand my rights under common law and Constitution, my human rights and God-given rights. And that's been violated so far, but I moved to dismiss based on that because the statutes, again, are it's all under military jurisdiction.
Yep, there it is.
Like I said, it violates Article 4, Section 4 of the Republican form of government, which means.
And I love that this judge, he teaches con law.
No statutes.
So you made a, Mr. Greco, do you have any response?
Yeah, my only response is that the entire argument is inapplicable here. He is subject to the laws of the state of Michigan and United States of America.
Do you think he's enjoying this? Probably not, because I don't think this is the judge's first encounter with this guy. And I think the judge has already lost his patience with this guy a long time ago. So whatever enjoyment he was getting at the beginning, he's not experiencing that anymore.
And is subject to this prosecution validly in this courtroom, which has jurisdiction.
There's no evidence to support that.
Your motion is denied for the following reasons. You argue that basically this court lacks jurisdiction over you. And that's just not true. The question of whether a court has personal jurisdiction over a party is a question of law. And the plaintiff, which is here, the prosecution, would bear the burden of just showing a prima facie showing that there's jurisdiction. And that's part of the elements. One of the elements is that all these allegations happened in the city of Taylor. And now, under Michigan Compiled Law 600.701, any individuals, it talks about individuals and it talks about general jurisdiction of the court. And it says basically that the existence of any following, the existence of any following relationships between an individual and the state shall constitute a sufficient basis of jurisdiction to enable the courts of record of the state to exercise general personal jurisdiction over the individual or his representative, and to enable such courts to render personal judgments against the individual or representative. 1, presence in the city at the time that you're served. So as soon as you got the ticket in the city, boom, that was the jurisdiction. 2, domicile in the state and or here in the city. You live in the city of Taylor, so your domicile is here. And the last one that you talked about is consent, and you said that you didn't give consent to, et cetera, et cetera. So in the present case, you are physically within the boundaries of the city of Taylor at the time of the alleged criminal activity.
Yep.
And because you afforded yourself the contacts and in there, that's as minimal contacts as you need for this court to establish jurisdiction. So for those reasons, and for reasons stated on the record by Mr. Greco, your motion is denied. So now let's start with the voir dire.
If I get a chance to respond, I want to say something.
There's nothing to respond to. I just ruled on your.
There is nothing to respond to. He made his ruling. We're moving on.
You came up with this motion last minute, and you brought it up. I've thought about it and made a ruling based on the law. And if you think that I'm incorrect in that, you can file an appeal.
Yes, and I'm going to, and I request now that these proceedings be stayed because I'm going to be appealing these denials. You denied all my motions in violation of the Constitution. So I'm move for a stay of proceedings until the appeal is decided on this issue.
Motion denied.
Motion denied.
There's no need to. That's not how it works.
Because interlocutory appeals don't work in criminal court. That's not how you do things.
So
the person's appealing an issue. That's how it's supposed to be.
All right, so we're gonna go off the record for a moment. Detective Corporal Chamberlain. All right, so
another motion to dismiss.
Say again, sorry.
No, another one.
And go ahead.
Based on the misconduct of police officer Anthony Borg. This is Anthony Borg. I had a chance to look at his name tag. But anyway, is this Anthony Borg?
I'm not here to identify people or answer questions. I'm here to make rulings of fact and law. So,
anyways, well, the police officer Anthony Borg that wrote the ticket. Okay, he was acting outside of his authority as a criminal law enforcement officer, and acting as a civil revenue officer because the purpose of the ticket was to help make the city of Taylor richer by trying to impose fines, etc. And yeah. I'll move the
Yeah. I don't understand what argument he's making. I'm going to wager a guess, just a guess, that a police officer is authorized to issue citations, both civil and criminal, as part of his duties.
Just on that, so that he was acting outside of his authority, so it's kind of on his part. So it should be dismissed based on that.
Mr. Greco?
Yeah, brief response. He was not acting outside of his authority. He's a police officer sworn by the state of Michigan and the city of Taylor, witnessed somebody committing a crime and issued a citation based upon that crime with this defendant committing that crime. That's why we are here. That's why we are alleging it. That's why we are pursuing the matter.
Additionally, I am,
Isn't,
go ahead.
say that. I don't want to catch up. So, respond to him. Respond to him. Respond to him. What he said. Okay, now isn't it true that the city is?
You can make argument, but you're not going to ask questions.
You can make an argument, but you're not going to ask questions of the prosecution. You can make an argument, but you're not going to question him.
Of the city attorney, that's not.
That's part of my right to.
No, it's not. No, it's not. No, it's not.
No, it's
But,
not.
okay, well, anyway.
No, you don't have the right to ask the prosecutor direct questions. No.
And I can ask the question. Don't say. I like the argument that that's not true because the tickets, there is a civil thing behind it where money's involved. So it ain't just like what he says. There is a civil thing. There's truth to what I said.
Okay,
so
so
tickets and it's a civil. Second is a civil revenue law.
So the penalty, the alleged or the potential penalty for violation of this crime is 93 days in jail and or up to $500 in fines. So if you get found guilty, you can just get 93 days in jail and there wouldn't be any money coming to the city. Matter of fact, the city would then incur a debt because they would have to pay, I don't know what it is, $37, $44, whatever it is, for every day that you're incarcerated. So actually.
Exactly. Yeah. The city's prosecuting this at a loss. That's another thing that these SovCits don't understand, especially when it comes to traffic court. Vast majority of these enforcements, they're enforced at a loss. They're not profiting off of your criminal case.
See, if we go through this whole trial and you get to be found guilty, you can get 93 days in jail, and there might not be any civil part of it at all. That's entirely up to me as a sentencing judge. So, and I haven't heard any testimony, I haven't heard anything because we haven't started the trial yet. So your motion is denied because it basically has no grounds at all. That's his job, is to do police work. And if it's not, if the allegations prove that you're innocent, innocent, that's fine. If they don't prove the case beyond a reasonable doubt for all the elements, then that's going to work in your favor as well. But we don't know because we haven't got to the trial part yet. But that is his job. If he thinks that there's reasonable suspicion that there's a crime going on and he sees that there's probable cause of this crime is going on and happening right in front of him, then he is sworn and duty bound to act upon it. Whether or not he's correct or not, well, that's what this whole trial is for today. So your motion is denied. Now let's bring in.
Can I elaborate? I want to elaborate.
No, you can do whatever you want on a
No.
I made my ruling on the motion. The motion is denied.
Denied. Nice. Well done. Well done, Judge. Efficient. And not taking any BS. Okay, I saw this. I saw people mention this in chat. I did not think it was serious. Russia fines Google a shocking $2.5 decillion for blocking pro-Kremlin media content. Decillion is 33 zeros after 2.5. So, well, there it is. All right, we're going to stop here. Guys, tomorrow, like I said, maybe Phasmophobia, maybe something else, but it's going to be spooky games tomorrow evening. Tune in for that on my gaming channel, so definitely check it out. Appreciate you guys. Take care of yourselves, and if I don't see you on the gaming channel, I will see you on Friday. All right, take care. Adios. Be well. Thank you all for the re-ups and subscriptions, and Mike also says bye. All right, take care. Later, guys.